Okay, hello everyone. Online, if there's any problems with sound, please shout in the chat. Dion's monitoring that. Otherwise, welcome everyone to our first Fringe event in York that we're holding inside a conference venue, so welcome all. I'm really delighted that we've got an amazing panel today. Akua Reindorf, Maya Forstater, Susan Smith, and Alison Jenner as well, chairing our event. I'm just going to do a few quick words of welcome and to just lay out the format. So we're going to have Susan speak first, then Maya, then Akua, sort of 12 to 15 minutes each. Alison gets the pleasure of asking them a question in between and introducing them. And then afterwards we're going to have a roving mic going round so people can ask questions. And please, if the question's for a specific member of the panel, please tell us, and then we can get as many questions in as possible. All right, thanks everyone, and I'll hand over to Alison.
Thank you. Good evening, ladies and gentlemen. Isn't it nice to be able to say that? Welcome to Liberal Voice for Women's Fringe at the Liberal Democrat Conference. We have about 50 people here in the hall at York, and about another 30 or so viewers on Zoom, maybe worldwide. I hope you've all come with questions to ask our distinguished guests, and for those of you online, you may know this already, but please put your questions in the chat, and our happy helping friend Dion will be negotiating those, passing them up to us later, and we'll ask them for you. So now to introduce our stellar panel, Susan Smith is a co-founder and director of For Women Scotland, a grassroots campaign group established in 2018 to advocate for the protection of sex-based rights for women and girls under UK equality law. She's been a leading figure in high-profile legal challenges, including the successful case before the UK Supreme Court, which delivered its judgment almost a year ago, which clarified that references to sex and woman in the Equality Act actually refer to biological sex and biological woman. Apparently, officially, that was not a victory, but we know it was. Her work focuses on ensuring that women's single-sex spaces, services and associations remain protected on the basis of biology. Maya Forstater is a name, I think it's a name like Hoover now, isn't it? Forstater. Everybody's going to be quoting your name forever, you know that. Is a researcher, writer and advocate on issues including sustainable development and equality. Until I looked up at this for this evening's event, I hadn't realised how many papers she'd produced on sustainable development and finance and various sort of things.
Yes, I did have a career before I left.
Absolutely fantastic list of papers. She's perhaps best known nowadays, though, for as being the claimant in the landmark employment case Forstater versus CGD Europe, where a higher court ruled in 2021 that gender-critical beliefs, sex realists, broadly the view that biological sex is real, is immutable and is distinct from gender equality, identity, are protected philosophical beliefs under the Equality Act 2010. She is co-founder and executive director of Sex Matters, an organisation working to promote clarity around sex in law and policy. And our third panellist tonight is Akua Reindorf KC. Akua is a barrister at Cloisters Chambers, specialising in employment, discrimination and human rights law. In 2021, she authored the widely discussed Reindorf Review for the University of Essex, examining issues of free speech, academic freedom and the handling of gender-related debates on campus. She was appointed King's Counsel in 2023 and frequently advises on complex cases involving equality and freedom of expression. And Akua is speaking tonight in a personal capacity. Now I'm going to hand over, Susan, to you. Thank you.
Thanks, Alison. That's very generous words there. So I'm delighted to be here. I'm going to start with a little confession. So I've supported several different political parties in my life. But once upon a time, I was mad enough to join one. And I joined one because I had ideas about local democracy and ties to Europe and voter reform and things like that. And then I found that I'd wandered into some kind of cult where a lot of people were saying that men could be women. And I used to help out my friend who was the local councillor around her leaflets. And we'd have chin wags about local government reform and things like that. And then one day I said, I think I'm going to have to leave this party because there's a lot of people who are saying some really weird things about sex and gender, and I got involved in this organisation called Women Scotland, and we think it's wrong. And she said, no, because we believe in things like democracy and liberalism, and we'll all have discussions about things, and we'll have a good conversation. And you should really talk to your local representatives like Alex Cole-Hamilton and Christine Jardine, and they will totally get it. They didn't. Anyway, neither she nor I are members of the party, and I still have my pin. There we go. And it's sad. It was very sad that when we tried to raise issues, we were shouted down and just largely quashed in a particularly illiberal fashion. So that's my little confession. So I'll start with, why was it that this became such an issue in Scotland, and why was it that we ended up going all the way to the Supreme Court? I think there are some interesting structural issues here. I don't know if people have seen the Denton's report, but a lot of the targets and methodology that's recommended in there was ideally suited to Scotland. It's a small country, it's easy to capture the levers of power, there's a lot of crossover within Civic Scotland, and there were a lot of third sector groups that were almost entirely funded by the government. And in particular, whereas groups like Stonewall came later in the rest of the UK to this, in Scotland, the idea of self-ID was embedded in LGBT organisations from the beginning. From the 1990s, they were talking about LGBT rather than just LGB. To the extent that in 2013, Scottish Trans Alliance had persuaded the prison service to adopt policies which explicitly allowed self-ID. And they said, this quote here, we strategised that by working intensively with the Scottish Prison Service, they would be able to ensure other public services fell into line. Because, of course, once you've managed to get a policy in place in the prison service where you have some extremely dangerous individuals, and you say that you can incorporate self-ID policies into a space like that, you can justify it anywhere else. So it was very deliberate. And in 2015, Scottish Trans Alliance, along with an individual who some of you may be familiar, called Marudal Wadwa, who was then working in Rape Crisis in Scotland, went to Westminster and actually argued that they should remove the genuine occupational requirement in the Equality Act, so that women could not be guaranteed female-only services if they asked for a female-only doctor, a female doctor or a female rape counsellor or something like that. I was reminded today that in 2018, at a Lib Dem Fringe event, Karen Lindsay had boasted that she'd invited James Morton, who was I mentioned before, was the CEO of Scottish Trans, and Emma Rich, who is then the CEO of Engender, to a Fringe meeting to bring light and kindness into the toxic atmosphere. And rather smugly at that point, she said, Scotland's feminist organisations are open to self-identified women who are feminists. There has been an enduring, healthy and respectful dialogue between all equality organisations. Well, this wasn't true. What had happened was that the links between these organisations were strong because of the size of Civic Scotland, and political pressure had been brought to bear on women's organisations. When Engender was going to have a meeting about the proposed reforms to the Gender Recognition Act, women decided to go along and ask questions, and Engender simply cancelled the meeting because they didn't want to take questions, and they put out a podcast instead to tell us why we were all wrong. Women on the frontline services said they were bullied. There was a lot of chat about how funding would be withdrawn. But as one Liberal statesman once said, you have not converted a man because you have silenced him. And I think that there was a big undercurrent in Scotland. So what specifically were we fighting about? Well, it was this thing called the gender representation on public boards. And it was the most insignificant in many ways piece of legislation. It was there to ensure 50-50 representation on public boards, which had largely been achieved. And there was an argument from the start about the definition of women, but this was all done at committee stage, and it was really very much a fringe interest. There was huge pressure from Scottish Trans Alliance to get this definition in that was based on self-identification. And that was what the committee, 6-person committee, eventually decided to adopt. And not a lot of people noticed it at the time. It was certainly never debated when the bill came to Parliament. But my co-director Trina noticed it, and it really rankled. But this bill had passed before we were even formed. I think that in retrospect, this story is about hubris and overreach, because they didn't have to write this into law. This was happening anyway. People were constantly being told that when we say women, we mean anybody who self-identifies as a woman. But because they explicitly went out and put this into a piece of legislation, we finally had something that we could go over after. And that's what we did, because we believe that by conflating these two protected characteristics, the government had acted beyond their competency. And we decided to take this to judicial review. Now, meanwhile, at the same time, the gender recognition reform was going through Parliament, and they were proposing to remove all safeguards and allow for self-identification to lower the age that you could apply for this. And there was already an unresolved confusion about the interaction with the Equality Act. So judicial review number 1, we eventually won in the inner court at the Court of Session, and the court found that the Scottish Government had conflated two protected characteristics, that they'd chosen a category, transgender women, which is not a category in equality law, and that they were constrained by the Equality Act definitions. And they said that in this context, this provisions in favour of women by definition exclude those who are biologically male. So we were absolutely thrilled. We thought, right, that's game over, we can all go home. Ho, ho, ho. So what happened? So everyone just carried on as if nothing had happened and continued to operate on self-ID. And we felt a little bit deflated at this point. Edinburgh Rape Crisis decided to hire someone who is biologically male to run their services, someone who was later found to have conducted a heresy hunt against a woman who said maybe they should listen to survivors when they asked for a counsellor. And the government then did something that at the time we were worried about, but actually, again, overreach. They decided to put out a new definition of women, and this time the new definition of women included male people who had a GRC that said they were women, and excluded women with a GRC. So this was interesting, because as they were concurrently steering gender recognition reform through Parliament, we ended up with this situation which we called Schrödinger's GRA, because this was apparently, when they were discussing it in Parliament, just a simple piece of admin that only changed what was going to be on your birth certificate and your marriage certificate, and as one SNP MSP movingly put it, imagine the pain of being married in the wrong gender. And at that point I remember thinking, if you're feeling pain when you're being buried, you've got bigger things to worry about. But in court, they were saying, no, a GRC allows somebody to take advantage of provisions designed for women. It changes their sex for the purposes of the Equality Act. So we thought, right, we have to do something about this. Even if we lose this, we're not going to be in a worse position. And we did lose it. A couple of times. We lost it in the outer court, and we lost it in the inner court. But what we had, and I'm sure as Akua will say, a lot of the lawyers at the time really didn't think we had a case, because I think the consensus was that this was what a GRC did, and this was why the idea of changing the Gender Recognition Act to allow for self-ID was so worrying for a lot of people. RKC was initially dubious, but Trina, who is heading for her honorary law degree, said that if you didn't have a consistent read-through of sex and the Equality Act, it would make a mockery of it, not least sections on pregnancy and maternity. And she pointed out that section 9.3 should apply instead of 9.1. This is a very technical point, but essentially what it means is that what she identified was that GRC changes your gender in law except for when it doesn't. And that's the legal argument boiled down to its basic. So even the Scottish lawyers, I think, at this point started to think, there might be some issues here. It might be a bit too Alice in Wonderland to say that you can have women meaning one thing in one part of this act, but another when you get to pregnancy and maternity. And they did actually at the Supreme Court start to say, well, maybe we should take it back to Parliament. And of course, this would have been an unworkable mess, and I think this was the position that the EHRC had got to by this point, that it was an unworkable mess and it needed to go back to Westminster. And I think Westminster should be very grateful to us that they didn't have to sort it out. Because I don't believe that you can have an act where you read a word differently in one section to another section without any guidance on how you're supposed to read it at any point in that law. It's a complete farce, and thankfully the Supreme Court agreed. And I think especially after they'd heard about pregnant men and definitions of lesbians, which are sometimes two women, sometimes a man, and sometimes a man and a woman, and sometimes two men. And the Scottish Government lawyer said she needed a flowchart to explain it. So, I think that in the wake of the ruling, obviously, we've had quite a lot of misinformation. There's been a lot of confusion. There's been some downright bonkers tribunals. And there's also been a realisation that some people were never interested in compromise. They're not content that gender reassignment remains protected, and that we have never tried to challenge that or change that. And we are quite happy to say that adaptation should be made for trans individuals, but some people just want access to all areas, women's spaces and services. And the big one is prisons at the moment. We have gone back to court. And these are some of the delightful people who have been, or were nearly, in the case of the chap in the middle, in women's prisons. We know currently we have 3 male murderers. The individual at the top left there is called Paris Green, or Peter Lang. He sexually tortured a man to death and left him to die while he ate a ham sandwich. He's attacked women in prison, he's attacked prison guards, he slept with women in prison. We do not know whether that was consensual or not. down at the bottom, second from the right, we have Alex Stewart, who stabbed a man 16 times, father of 2 daughters. He is in a relationship with a woman who murdered her 2-year-old stepson, so she's a dangerous woman, and they control the prison in a quite terrifying fashion. So we think that there is an issue that the Scottish Government need to resolve, and we've gone back to court. Unfortunately, they are saying that they have to have these men in female prisons to preserve their human rights. Now, why these men have to be in female prison to preserve their human rights, but the majority of trans-identified male prisoners are kept in the male estate, we don't know why that's not infringing their human rights. And essentially what they're looking to do is relitigate the Supreme Court, because if they've got a human right to be in a female prison, presumably they also have the human right to be in a female changing room. I think there's a reason that redefining women was done very quietly and in this very under the radar sort of way through the Gender Representation on Public Boards Act, because all the internal contradictions crumble at the first breath of any kind of logic. I think you have to have honest debate about anything. You have to be able to present evidence, and I don't think that policies that are made in the dark can withstand light, especially when the light is the light of truth and science and law. I think that we have come a long way, but I would hope that we've got further to go, and I would like to see women's rights properly restored across the UK, and I hope that this is the first stage to it. It's proving a longer slog than we anticipated, but I think we're getting there. Thank you.
Thank you very much, Susan. I've got a question for you, and then we'll go on to Maya. We're collecting questions now in the chat online, and also I'm hoping you've got questions amongst people in the audience tonight. The Supreme Court decided that sex and woman meant biological sex and biological women, and our party then adjusted their internal election quotas for federal committees to apply on the basis of biological sex, excluding trans-identifying males from women's quotas and trans-identifying females from men's quotas to comply with the Act. As the lead campaigner behind that precedent, what do you make of this change, and do you see it as a model for how other parties and organisations should now handle sex-based positive action measures in their own elections and processes?
Well, I think, that what we were taking the government to court over was specifically a positive measure bill. So it flows directly from that. Anybody looking to have quotas for men and women have to count them in the correct ways. That doesn't preclude them having different quotas if they want to do that and they want to make that argument. But I think we have to ensure all the time that data on sex is robust and that people are following the law on this. So yes.
Thank you. So we have to follow the law. That's no two ways about it. Thank you. Now, can we go to Maya, please, and over to you.
Thank you. Thank you for the T-shirt. I heart the Equality Act. You're going to get one, I think. Yeah. I really do heart the Equality Act. When I was in the process of losing my job, before I lost my job, I had a Twitter account, and it was at 2010 Equality when I sort of started tweeting about this, and I just thought that I wanted to talk about the reality of men and women, and I thought the Equality Act was the important thing, and the EHRC and the terrible job that they were doing at the time under the previous management. So I've been following the Equality Act for a long time. So I'm going to talk about where are we now. The Supreme Court's judgment was absolutely comprehensive and clear. It took apart the Equality Act piece by piece and looked at How does it work? What's its purpose? Not just the words, but what is it for? And the fact that we got there from decades of equality law, sex discrimination, race discrimination, gender reassignment discrimination, how had it all been put together and how could it work coherently? My favourite paragraph of it is 209, where they've gone through the core provisions of the Equality Act. They do get to pregnant men and these kind of odd things, but they start with what is the Equality Act for? How does it protect people against discrimination? And they look at that and they say the core provisions which refer to sex, man or woman, are not capable of being fairly and consistently read with the Gender Recognition Act changing sex for all purposes, without defeating the purpose and meaning of the Equality Act. And we heart the Equality Act. Sex has its biological meaning throughout the legislation. Women always means a biological female of any age. Woman does not mean, or sometimes mean, or include a male of any age who holds a gender recognition certificate, or exclude a female of any age who holds a gender recognition certificate. To reach any other conclusion would turn the foundational definition of sex on its head and diminish the protection available to individuals and groups against discrimination on the grounds of sex. We should have been able to just go home after that. It was absolutely clear. It's really powerful. It says that this act, which is meant to protect women and men equally from sex discrimination, only works if you're clear who's in those categories. And that had to be the right answer. I'm hugely grateful to For Women Scotland for getting us there. And then we got there. It's simple. We've got this law that applies to every workplace, every school, every university, every business, all parts of public services. Is it going to work in this kind of crazy way with these secret certificates that no one understands, or is it going to work with material reality and simple words that everyone understands? We got there eventually, and the answer is really, really simple. And then the Equality Act itself, it basically says don't discriminate against people based on protected characteristics. That's about 3 pages. Apart from where you can. That's the other 200 pages. And for good reason, because if you say don't discriminate on the basis of age, well, of course you discriminate on the basis of age all the time. You have playgrounds for children, you have playgrounds for teenagers, you have things for women and things for men, and if you treat disabled people as if they weren't disabled, then you're putting them at a disadvantage. So it's don't discriminate against people apart from when you should. And this case covers 3 protected characteristics out of 9. So it's really important. It covers sex, it covers sexual orientation because that's based on sex, and it covers gender reassignment, the protected characteristic of trans people, which is defined very broadly in terms of someone who's proposing to undergo or has undergone some part of some process of a personal journey of reassigning their sex, whatever that means. Anybody who identifies as trans is probably covered by this protected characteristic, and they're covered in the same way as all the other protected characteristics. You shouldn't be sent to the back of the bus, you shouldn't lose your job, you shouldn't be paid less, you shouldn't be harassed, you shouldn't be passed over for promotion or not allowed to rent a flat. All of those things are what the Equality Act is meant to protect everyone from, including trans people. But what it can't do is change your sex, because that would be magic. And so the important thing that the Supreme Court said is when you're trying to work out if someone's been discriminated against, you have to compare them against a person without that, with a protected characteristic and without that protected characteristic. And so in order to have the protections against sex discrimination, you have to be able to compare a woman with a man. What if the man has long hair? Or what if he wears makeup? Or what if he has female pronouns or a woman's name? Or wears women's clothing? He's still a man for the purpose of comparison with a woman in relation to sex discrimination. That's what the Supreme Court says. So that's the 3 pages. Don't discriminate. And then there's the 200 pages, which is apart from where you can. And that's what covers single-sex situations. And the reason why we have single-sex situations where you're allowed to discriminate is because men and women are different, because we're mammals, because we procreate, we have children, we breastfeed. And even if you don't do that personally yourself, it is for those reasons that women have been oppressed, exploited, discriminated against for recorded history. And so there are all these provisions within the Equality Act to allow for the places where women and men have different needs, different vulnerabilities. And I think there are 7, there's probably more, but 7 big ones. Positive action. As Susan said, that was what the case was about. Positive action is when you're doing something to meet a particular identified need or vulnerability of a group that shares a protected characteristic. Women share a protected characteristic. They don't share the protected characteristic with people who identify as trans women. We just don't. They have their own vulnerabilities. I do not know what it's like to be a trans woman. Secondly, associations. People are allowed to associate basically in any way they like. Freedom of association means you can have groups based on religion, groups based on age, groups for young Christian men. You can add together different protected characteristics, and you can have groups that are female only and male only. Then there's charities, really important. Charities are a form of positive action, also a form of association. They're things that people do outside of the state. They choose to do it because they see a need of a particular group. They get particular benefits from being a charity, and they have to follow their objects. And women's charities meet the needs of women at their most vulnerable. There's also a particular exception in there for fun runs, charity fun runs. They can be single sex too. You can tell they just went through and thought about all the places in society where people want to do things for a single sex reason, where it's a good reason, not a bad reason, and they try to put something in for that. Sport, obviously, we do sport with our bodies. Single sex schools, single sex colleges, and then single and separate sex services, which covers everything from toilets, changing rooms, to rape crisis centres, to men's mental health groups, to anything where there is a proportionate means to a legitimate aim for doing it on a single or separate sex basis. That's it. Other than that, dress however you like, call yourself whatever you choose, sleep with any consenting adult who'll have you, as a very great woman once said. So, I'm not a lawyer, I try and make it as simple as possible. Sex Matters tries to make it as simple as possible. You should have a copy of our little booklet. We think the law should be clear and simple, and it is, but it hasn't quite worked like that. Following the judgment, the big thing that everyone is saying is we're waiting for the guidance. They don't need guidance. And the government has said they don't need guidance. But the civil service also say we're waiting for the guidance. So we're all waiting for the guidance. Some organisations have moved. Straight after the judgment, the Football Association, England Cricket, England Netball all moved to make their teams and rules single sex. Girl Guides, Women's Institute, women's charities took their time, but they got legal advice and they realised that they had to be single sex. People are bringing cases. We worked with Michelle Dewberry and threatened to sue Virgin Active over their changing rooms, and they realised that they needed to make them single sex. Sex Matters is in a legal case against the City of London over the Hampstead Ponds, which is an iconic location, whether you like swimming in cold, muddy ponds or not. It's a really good demonstration of what a single sex service is. I've been in correspondence this week with the General Counsel of Marks and Spencer's, who told me that he said, we've always had unisex changing rooms. And I said, that's funny, because on your website, if you look at every single store, it says you have men's changing rooms and women's changing rooms. So let's see what he says to that. So the law is clear, but people are taking their time complying with it. Quite quickly after the judgment, the Equality and Human Rights Commission brought out a really, really good, simple, one-page explanation of how it works for single and separate sex services. That was challenged by the Good Law Project, and it was upheld by the High Court as being an accurate explanation of the law. So thank you very much, EHRC, and thank you, Jolene Morn. We now have a one-page, clear, practical explanation of the law. And can I tell you one story about that? So my thing is, I think things should be as simple as possible, simple words and pictures. And when the Gender Recognition Act consultation was going on about self-ID, the government released this they released this easy read versions of documents. Few words, pictures, make it simple. It was crazy. The way that they described a gender recognition certificate was there was a picture of a man and a picture of a woman and an arrow that went between them. Like, this certificate could change the man into a woman. And this is trying to make the concept simple. But the idea of having easy read versions, I think, is really important. When the Equality and Human Rights Commission in 2022 put out guidance on single-sex services, we at Sex Matters tried to make a simple, easy-read version. It was impossible. This was when people still thought that gender recognition certificate changed your sex for the purposes of the Equality Act, and you could not explain this guidance with simple words and pictures. But this one page from the EHRC, you can, I think. So there are companies that do this, easy read documents. So I commissioned one and I said, can you turn this into an easy read version? And they said, yes, we'll get back to you on Wednesday. Then about an hour later, they emailed me and they said, we don't think we can do this. I said, why? And they said, it's the context. So I've sent them an easy reading email. Look up Forstater. Look up belief discrimination. Really, really, you don't want to do this. I mean, this is what is still happening. We get turned away from venues, we get turned away from businesses. We use the Equality Act to try and get people to comply with the law. We're going in the right direction. So my message is really, use the law, use your voice, keep it simple. You don't have to be a lawyer. It's there for everyone to use.
Thank you so much. I've got a question for you, just to kick off responses. You mentioned the ladies' pond, and I know you personally, as well as Sex Matters, have been involved in that case right from the off. What practical changes do you hope to see in public spaces after the Supreme Court clarification?
It's interesting. I don't know if I don't know if I'm imagining this, but you know the signs when you go to a toilet and they say there may be a cleaner and it used to say there may be cleaners of other genders, and I'm seeing much more signs now that say there may be male or female cleaners. It feels like people are feeling like it's not terrifying to say male and female, rather than, you know, many genders, other genders. There actually are only two sexes, there are only two kinds of people, and there are three kinds of spaces. There are spaces that are mixed sex, like this one. There are spaces that are male only, and there are spaces that are female only, and those are the only options. And I think we are seeing organisations kind of recognising that the best way to avoid conflict is to be clear about that. Be clear and simple. That's what I'd like to see.
Thank you. That's great. And now, Akua, over to you.
Thank you very much. Thank you, everybody, for coming along. So Maya has said in her talk that we should have all been able to go home after the judgment in For Women in Scotland, and I did think that that was what was going to happen. I was starting to think, what am I going to do for a job? And think about finding some new specialism. But actually, happily for me, but unhappily for everybody else, it has been a rather different story in the reality. And since the judgment, since minutes after the judgment was handed down in April of last year, there has been a tsunami of disinformation and misinformation about it. So what I'm going to do is a little bit of myth busting. Some of the main myths, I'm going to address some of the main myths that have been spread about the judgment, and then I'm going to talk very specifically at the end about lesbians, which is an issue very close to my heart, and an issue which the judgment is very important in relation to. So I will heave off with my first piece of misinformation, which is actually one which comes from the source of the gender critical side, which is that the Supreme Court judgment makes self-ID unlawful. We saw after the judgment that there was an enormous public reaction, really quite surprising to those of us who'd been involved in the case. And you know, suddenly the whole country was saying, oh, we can't let trans-identifying men use women's spaces anymore. The reason why this is a myth is because it was in fact For Women Scotland 1 that Susan talked to us about earlier on, which established definitively, it was already well understood by specialist lawyers, but For Women Scotland 1 established definitively that self-ID was never part of the Equality Act. The Equality Act never allowed anybody with the protected characteristic of gender reassignment to identify into opposite sex stuff, essentially, because of the way that comparators work, which has been touched on, and I won't take you down that particular rabbit hole again. The For Women Scotland 2 in the Supreme Court was only about what the effect of a gender recognition certificate was on somebody's sex for the purposes of the Equality Act. So it had a very narrow subject matter in that sense, but what it did do was that it went over the entire terrain and gave some very useful guidance which does sort of help to focus the mind on everybody's situation, including those people without gender recognition certificates, and also gives some very good legal principles, sets down some very helpful legal principles in that respect. Some of the more egregious myths I will go on to now. Second on my list is the civil servant who wrote the Equality Act said that when she wrote it, it meant trans women are women, and so the Supreme Court is wrong. Said civil servant being somebody I know, who I feel should have known better than to write this in a Guardian article. I mean, for one thing, she didn't write the Act. But secondly, it's irrelevant what any civil servant meant who contributed to the writing of the Act. It's irrelevant what the minister thought who brought the Act through Parliament. it's irrelevant what any of the individual parliamentarians meant who voted on it. When the Supreme Court decides what the intention of Parliament was when it passed an Act of Parliament, which is what its job is when it's interpreting legislation, that's just a metaphor. They're not looking at what was the intention of the sort of 610 individual parliamentarians when they voted for it. What they're looking at is what the words of the Act objectively mean in their context, or having regard to their context, and given the purpose of the legislation. And that is what the Supreme Court did with a very fine scalpel. And what they found was that the intention of Parliament, as in the objective meaning of the words, was that if men and women were single-sex categories, and if they were mixed-sex categories, then you couldn't make head or tail of the Act. And so it was quite plainly not the intention of Parliament, because it can never be the intention of Parliament to make an Act which is incoherent. So they very firmly decided that Parliament had not intended to make an incoherent Act, and that men and women were single-sex categories. Because you simply couldn't make sense of the Act if you have women including some men and men including some women, even down to its very most fundamental concepts like comparators. As you know, direct discrimination is a very key concept in the Equality Act, and it depends on being able to compare your treatment with somebody of the opposite sex when it's direct sex discrimination, and it becomes a terrible muddle if you have a mixed sex group comprising women, and it just becomes more and more labyrinthine as you go into it. So the Supreme Court, I mean, I was there for the entire hearing, so was Maya, and obviously Susan was, and you know, you could see it on their faces as they got further and further into the weeds of it, how they were just astonished. I mean, you could see people peek, some of the judges peeking in real time. It was quite extraordinary. But no, so that's what they found, was that the intention of Parliament was that sex was a different category to gender reassignment, and it meant biological sex. And if what said civil servant thought the Act was intended to do when she was working on it back in the early part of the century, was to sort of enshrine the principle that trans women are women into the law, then all that means is that she failed to do to write a proper Act. You know, I mean, and so did government. If government meant the Equality Act to give right to self-ID, they failed to do so because they wrote an Act which didn't do it. And frankly, I mean, all you have to know is that we have a Gender Recognition Act which gives people some of the rights of the opposite sex. If the Equality Act was meant to give self-ID, then there would be no need for the Gender Recognition Act. So you can see it's incoherent just from the get-go. Number 3 in my list of misconceptions about the Act, they didn't hear from trans people. The Supreme Court didn't hear from trans people. They didn't hear evidence from trans people. They didn't hear evidence from anybody. It's an appeal court. They don't hear evidence. Appeals are on points of law. Now, it is true to say that some of the interveners did adduce some evidential material, but it was sort of in support of their legal arguments. They had to show first, in order to be an intervener, you have to show first that you have something useful to say about the legal propositions, which isn't going to be just repeating what somebody else has said. And so they used evidence that was illustrative of the legal propositions that they were talking about. There were a couple of trans applicants for intervention who didn't gain permission for one reason. I mean, we don't know why, because the Supreme Court doesn't publish its reasoning, but one can only assume that they didn't have something of interest to say about the law. And I suspect that they were talking about lived experience, which is not what the Supreme Court has any interest in at all, and that's not meant to be offensive, it's just simply not what they do, it's not their job. And in any event, the Scottish Government and Amnesty both made very extensive submissions. I mean, the Scottish Government was the defendant to the case, and they were wholly on the trans activist side, as were Amnesty. And in fact, one of Amnesty's lawyers was trans or non-binary. And to some extent, the EHRC made submissions in support of the other side as well, although we draw a veil over that for these purposes. So that's that. They didn't hear from trans people is an argument that just goes nowhere and means nothing from a legal perspective. More importantly, and this is the argument which has really taken on some legs, piece of misinformation that's taken on some legs, is they didn't consider the human rights arguments, which is what we are now bedeviled with at every turn, this argument. And this is what Good Law Project basically bring. Every challenge that they try to bring is based on this premise that the Supreme Court's judgment is somehow flawed because they didn't go into the human rights arguments. I mean, I find it difficult to talk about this without becoming emotional because it's so frustrating. Amnesty did talk about the human rights points in their skeleton argument at very considerable length, and they argued that if the Equality Act was interpreted by the Supreme Court in the way that was proposed by For Women Scotland, then that would be incompatible with the human rights of trans people. And yet the Supreme Court, which is under a duty to consider human rights principles at every stage of its reasoning, decided that the law was to be interpreted in the way that that For Women Scotland proposed, and therefore we can only reasonably accept that they considered carefully the human rights arguments that were proposed by Amnesty. I mean, and in any event, they referred to them in the judgment, and they referred to many of the cases in the judgment, and there's just no basis for this. But it's taken on the quality of a piece of scripture. The idea that at some point the Supreme Court judgment will be overturned by Europe broadly, and they mean Strasbourg, they mean the European Court of Human Rights, because Strasbourg will agree that the Supreme Court didn't consider the human rights arguments. And the idea, to my mind, is verging on dishonest. If money is being taken from people who are contributing to crowdfunding on the understanding that there is some holy grail where Strasbourg rides into the rescue and snatches the Supreme Court judgment away. And I've seen online many people who believe that is what's going to happen, and that it's almost a foregone conclusion. They really are putting good money after bad. I mean, there's no legal basis for the argument, needless to say, in any event. Okay, next misconception is that single-sex spaces are permitted by the judgment but are not compulsory, and everything has to be done on a case-by-case basis. A case-by-case basis is where we were at before the judgment. So this argument, which is made very frequently, is an argument for going back to the status quo ante, and it's legally misconceived. It is right that the Equality Act does not mandate single-sex services as such, but through various mechanisms they are, or they may very well be, mandatory in many circumstances. So in employment situations, for instance, there's other legislation which mandates single-sex facilities in workplaces. In service provision, so somewhere like this hotel, the toilets don't have to be, under the Equality Act doesn't say that the toilets have to be male, female, but if the service provider, if the hotel group failed to provide separate toilets for women in particular, they may very well be discriminating unlawfully against women under the Act. So it's a little bit more complicated than just saying, oh, the Equality Act doesn't mandate it. But essentially what the Supreme Court judgment said was, yes, you can have a blanket rule about services, which really shouldn't be a surprise to anybody, because we have blanket rules all the time in society. We have a blanket rule that you don't go over 70 miles an hour on the motorway. We have all manner of blanket rules. The idea that we can't somehow, because this situation is unique in some particular respect, is for the birds, really. The Supreme Court was clear that you can have, once you have shown that it is a proportionate means of achieving a legitimate aim, to have a single-sex facility or service, then you can have your blanket rule, and that's the end of it, and it should really be that simple. It is that simple. And there is no... The case that the Good Law Project brought against the EHRC recently, which was against the interim update that Maya's spoken about, the judge in that case, thankfully, has essentially agreed, yes, you can have a blanket rule. I mean, that's another issue, is that there was an enormous amount of dishonesty about what the judgment in that case was within minutes of it being promulgated. But the fact is that EHRC won the case, outright, and the case and the basis on which it won it was that it said you can have a blanket rule in this situation. So another piece of misinformation is that the case wasn't about single-sex spaces anyway. It was only about Scottish public boards. I've heard that being put in a court of law by a barrister, quite amazingly. It was about the Equality Act. Obviously, fundamentally, it was about the public boards and representation on public boards in Scotland, but it was unambiguously about what was the meaning of the word woman and man and sex in the Equality Act as in general. And there are whole sections of it which relate specifically to single-sex services and talk, because it was what the Supreme Court decided to do, which the court below had declined to do, was to go through the entire Act with a fine-tooth comb and look at how it worked, and look at the nuts and bolts of it. And they looked at the nuts and bolts of single-sex services and very clearly made their decisions about what the law says on those. So no, there's no basis on which you can say it's only about public boards, none whatsoever. And similarly, you can't say, because the next line of defence is, and the next piece of misinformation is that the case is only about the Equality Act, it's not about other legislation. So, for instance, where you have in employment situations that other legislation, which is 1991 health and safety regulations, that mandates single-sex facilities in employment, what Good Law Project argues is, well, the words man and woman and sex in those 1991 regulations that doesn't mean biological sex, that means self-ID, or it means people with gender recognition certificates, or it means people who have reached a certain point in their transition. I mean, all these things were argued in the High Court recently. They became quite desperate actually, because they did that peculiar argument about if you've reached a certain point in your physical transition, then you become a member of the opposite sex under the 1991 regulations. I mean, it was like it was Alice in Wonderland stuff. The judge gave it very short shrift. The truth is that the Supreme Court set out a test, very clear test, in the judgment about what the circumstances were in which sex, when it's referred to in any piece of legislation, will mean biological sex, and the circumstances are where the legislation wouldn't make sense otherwise. And really, when you boil it down, well, when you look at it more, carefully and try to apply it to different pieces of legislation, what you find is that sex means sex in situations where other people's rights are involved, other people are affected. And sex can mean sex as modified by a gender recognition certificate in situations where it doesn't really engage other people's rights. So we go back actually to what the Scottish Government used to say the purpose of the GRC was, which was to enable trans people to be, buried in dignity and so on, and have bits of their relationships with the state regulated in a way as though they had changed sex. Sorry, excuse me for my breaking voice, it's neurological. So it's things like what your paperwork says and what your death certificate says, and things where other people aren't directly impacted. I mean, there is an argument that statistics ought to be accurate, and so those sorts of relationships with the state equally shouldn't be affected by a GRC, but I mean, that's for another day. The fact is, at the moment, if you've got a piece of legislation which distinguishes between men and women, there's usually a reason for it, and if that reason, well, there's always a reason for it, and if that reason is to do with, making sure that there's fairness between the sexes or representation or something of that sort, then you will find that the testing for women in Scotland means that you can't, that the Gender Recognition Act cannot operate for the purposes of that piece of legislation. So that piece of, and I mean, just try to imagine how complicated things would be if you had one set of regulations which say you have to have single-sex facilities in the workplace, but they should be on a self-ID basis, alongside, which is you can't bring a claim under those regulations as an individual. You can only bring a claim under the Equality Act about single-sex facilities in the workplace, and then you'd have a completely different definition in the Equality Act. So it would just be madness. I mean, it would be great for lawyers, but it would be completely unworkable for everybody else. So that's also wrong. And the big one is, the big piece of misinformation is the judgment isn't law yet until we get the guidance. Which, I mean, I never thought I would see the day, frankly. I remember, I'll never forget when Stonewall tweeted that out. Do you remember? When we were at LSE, it was like 2 weeks after the judgment, and they genuinely posted on different social media platforms, at least on Blue Sky and Twitter, or maybe it was just Blue Sky, that the judgment is it. So they said, remember, the judgment isn't law as yet. And, we have to wait for guidance to be published. And, I mean, I despair, really. This is such incredible nonsense. I mean, the Code of Practice, which is what people think they're waiting for, is not even law. It's statutory guidance, so it has no legal effect. Tribunals and courts, if they're deciding a case where they think that there's something in the Code of Practice which might be relevant, they have to look at the Code of Practice. They don't have to follow it. It's not legislation. Thank goodness, the people who work in the EHRC who write the Code of Practice, fantastic as they are not legislators, which is, they don't have the right to make legislation. It would be quite extraordinary if they did. So waiting for guidance is the very last thing that anybody should be doing. The law is the law. The Supreme Court judgment is the law, and that is the beginning and end of it. Furthermore, any employer waiting for the Code of Practice is making a very grave mistake, because the Code of Practice is not about employment, it's about services. And the law is completely different for employment and services, really completely different. So it staggers me that we have bodies like the civil service still saying, and NHS trusts still saying we're waiting for the guidance. And it also staggers me that we still have the government giving such weak leadership on this point. Only when absolutely pushed to say it will they say, yeah, you don't have to wait for the guidance. Meanwhile, the guidance is gathering dust on Bridget Phillipson's desk for no reason, no compelling reason that has yet been shared with us. So, wait for the guidance is the worst piece of misinformation that's out there. So hopefully I've covered off I've probably gone way over time, hopefully I've covered off most of the pieces of misinformation, but the key takeaway from all that is just follow the law, and follow the Supreme Court judgment, which is really incredibly simple. It really is. If you've got a service or a facility which is single sex, then it should be single sex, and it makes provision for people who identify as the opposite sex as appropriate by, for instance, having a unisex toilet that can be used by anybody who doesn't want to use the single-sex facility for their own sex. It really, really is not complicated. Now I'm just going to address quickly the lesbians issue. The lesbian interveners, the most brilliantly named party in any court case ever, as far as I'm concerned, really swung the judgment. They really swung you could see when the Supreme Court was looking at their intervention, at their written intervention, how compelling they found it. Because lesbians have been uniquely affected by gender identity ideology. Because, lesbians are, affected by patriarchy as well as by homophobia. Previously, if the law was as Scottish Government wanted it to be, and as Good Law Project wanted it to be, and trans activists generally, then a lesbian would be really anybody, quite honestly. I mean, if you're a woman you'd be a woman who's attracted to women, men who have gender recognition certificates, and who are attracted to other No,
not attracted to women with certificates.
Who are not attracted to women. No, yeah, let me do it. Women are attracted to men who have gender recognition certificates, but not to men who identify as women who don't have gender recognition certificates, and who are attracted to women who don't have gender recognition certificates, but not to women who do have gender recognition certificates. That's what a lesbian would be. I mean, the same goes for gay men, but gay men don't have it quite as bad because they're not placed under quite the amount of pressure. I mean, you can see how misogynist trans ideology is when you look at how often, for instance, women are placed under pressure, young women, young lesbians. It breaks my heart, the extent to which young lesbians are placed under pressure to widen their dating pool to include men. I find it absolutely horrific. So if the law was as the other side would have it, it would be illegal for women, lesbians, to hold single-sex events and to have single-sex associations, because one really important part of the judgment is that the law relating to associations, which is like clubs and groups and so on, of over 25 people, doesn't have a relevant exception. So you can't really mess about with it to the same extent as you can with services. So lesbian women would not be able to have lesbian-only associations. They would, as in Australia, as is the case in Australia now, they would have to allow men with gender recognition certificates to join their association, which would be atrocious. And when the Supreme Court, the lesbian interveners had said in their written submissions that lesbians are not attracted to pieces of paper, and that line made it into the judgment. I was very pleased to see, and it really, really did swing it, because it's so preposterous when you look at it, and when you also look at it alongside the decimation of lesbian social life that there has been over the last 10 years in this country. There are no lesbian bars left there are almost no, I mean literally none. There are no proper lesbian associations. There's nothing for young lesbians who are just coming out and just trying to find their feet in their sexual orientation, and it's the only sexual orientation that doesn't involve men. So it's uniquely sort of challenging to navigate the world in a way which excludes men in that respect, and it's to be celebrated that the Supreme Court, and I hope that the Supreme Court judgment results in a revitalisation of lesbian life in this country. I'm sure it will.
Thank you, Akua. I've got a question for you. What's the likelihood of the government agreeing to alter the Equality Act to modify the protection for women's single-sex spaces, to mollify trans demands for inclusion of biological males in women's spaces?
At zero.
Because
they're not complete idiots. I mean, they don't want to touch this subject with a barge pole, let alone get involved in amending primary legislation. I mean, they are able to see that this subject is a viper's nest, and that's presumably why they just are trying to sit still and wait for it to pass without speaking, moving or breathing until everybody's forgotten, having completely underestimated middle-aged women. Well, you've got to say. So the idea that they're going to open up the Equality Act is for the birds, I'm afraid. And I know that there are plenty of backbenchers in the Labour Party who would like the law to be different, but even they, insofar as they understand anything much about it, which they don't, but if they, from what they, for the few glimmers of understanding they do have, they have seen that asking for the Act to be amended is not a sensible ask. So what they're doing, as a result, is just trying to spread some kind of different idea about what the judgment means. But I have said many a time, and so have lots and lots of people, your only option at this stage is to amend the Act. If you want the law to be different, you have to amend the Act. And nobody's even talking about, maybe one or two people are talking about that, but hardly anyone. It's just not going to happen.
We're going to open it up. We haven't got a lot of time, but we're going to open it up to questions from the audience, and we've also got questions from the online audience. So what I'd like to do is take them alternately. So has anybody in the hall got a question for us? Thank you.
Hi, I am a gender critical woman in the sense that I believe women are born. But I'm wondering about data, and I'm wondering about the moral panic about all of this. Anybody like to guess what the current population of the United Kingdom is?
About 69 million.
69.3, you're quite right. What percentage of the British population or the United Kingdom population self-identify as trans? Anybody know?
Tiny, 0.2%, 0.02%.
No, I'm asking, that's the exact question. Self-identify, self-declare. How
I think
many?
it's about 0.02%.
It's
Something like that.
0.05.
Right, almost.
Okay?
More than I thought then.
And here in your literature we have something verging on, oh my goodness, 9,000 people have applied to have their passport, or their this or their that changed. So the question I want to ask all of you is, and I completely approve of the Supreme Court decision, by the way, because law should always be clear, but are you concerned at all about the plight of transgender people beyond just having unisex loos? So, for example, a little boy who is incomfortable in his identity as a little boy wants to go to a girls' school for a couple of years, and he might change his mind. Where is the harm in that?
Yeah, I'll definitely take that.
Oh, anybody on the panel? Because
So
I'm
I think we're all going to answer.
horrified by thinly veiled transphobia masquerading as this group daring to say they speak for liberal women. They don't. They are the voice of illiberal women, and I
It's okay,
just
we'll
want to
answer
make
the
that
question.
quite clear.
We're all very happy to answer the
That was a good
question.
question.
Yeah, I mean, I'll say first, I'm not speaking for liberal women, I'm not a Lib Dem. Yes, I'm very concerned about the plight of people who identify as trans, especially the children, and especially a 4-year-old child who is being affirmed in the idea that he or she may one day be able to change his or her sex. I think it's a crime against humanity. I really do. As for adults, if I may finish, as for adults who are of an age and robustness that, or who are not vulnerable adults, I am perfectly happy with the extent of protection which is provided by the Equality Act, which is very extensive. It does everything for people with the protected characteristic of gender reassignment that is done for every other protected characteristic in the Act, and I'm perfectly satisfied that that protection should be extended to people who have that protected characteristic. I have absolutely no problem with it at all, none at all. I don't see any reason why people who adopt a gender presentation or have that's inconsistent with traditional notions of gender stereotypes or manifest a trans identity in any other way, I don't see any reason why those people should be subjected to harassment or discrimination for that reason, and I'm glad that we have protection against it in our law.
Thank you.
Alison, do you want to do one online now? Well, how long have we got? We've just got till
15
past.
minutes. Okay. In that case, the first question we had online was from Trish, who says, is it legal for the Women's Institute to make it a condition of membership that all WI members sign up to their new EDI policy, which is written from the extreme end of gender ideology, and ignore women who are sex realists?
I don't think so. I think that could be belief discrimination. Women's Institute is a single-sex charity. Its objects are to support the education and welfare of women. So it's allowed to exclude all men. In fact, it must exclude all men, but it can't exclude people on the basis of other protected characteristics. That's what the association's rules say. So it can't exclude you because you're an atheist, or because you're a Muslim, or because you're Jewish, or because you're gender critical. So I don't think they can do that.
Thank you. Susan?
On that one, or?
Yeah, that one. Or alternatively, there's another question from India on rather somewhat similar lines about girl guiding. Let's just get India's question. What she says is, what can be done about the girl guides using girls in their trans propaganda, and about them trying to circumvent the law and include trans-identified boys and men? The GG are talking out of both sides of their mouth.
Yeah, I think it's desperately sad actually, because girls, especially girls and young women, are often very eager to please. And I think that any organisation using them as some kind of propaganda and a political campaign led by adults is pretty appalling. I don't think these girls... I think the reason girls need sometimes spaces away from boys are well known. You hear this all the time in schools. They say they will move the troublesome boy to sit next to the nice calm girl because she calms him down. And the impact on girls is often never considered. So sometimes when you have these single-sex spaces like guides or single-sex schools, they are rare. They are not the norm. We live in a society where most things are unisex and most children can get on with that just fine, but in some cases, girls need that little bit of extra help and support, and they want to be around their peers, and I think they deserve to be. That, you know, if girls want to join a mixed-sex organisation, they can join the Scouts. If the helpers want to join a mixed-sex organisation, they can also join the Scouts. If they say the Guides is going to be just like the Scouts, well, what's the purpose of the Guides? You know, the purpose of the Guides is set up specifically to cater for girls. I would just say that, you know, having a couple of boys or a couple of men, it is well known in a room full of women, it alters the dynamic. We all know this. Women stop talking, they sit back, they allow the men to take over. So I think, you know, when we say it might only be a couple of people can make a huge difference. And I would go back to the prison example. 3 men in Scottish women's prisons have caused immense trauma, and we should never be prioritising male people over women's safety and dignity.
And just on the Girl Guides point, in terms of what should we do, there is a regulator. It's the job of the Charity Commission to make sure that charities follow their objects. You know, we've talked about the law. There are cases of individual people bringing claims. We've all become lawyers and, you know, understand far too much about the Equality Act that we shouldn't need to. It's for the regulators to make sure that these things are followed. It's for there's a regulator for health and safety at work, there's a regulator for charities, there's the Ofsted, there's the Care Quality Commission. The lady over there asked, where is the harm in allowing a boy to join a girls' school as a girl? Anyone who looks at that in terms of risk, you can see where the harm is. A girls' school is set up to keep girls safe. It's not set up to have boys in the role of girls. It can't be done. But it should be for the regulator to say, no, you can't do that. If you're a girls' school, you're set up to accommodate girls, to keep girls safe. You're not set up to affirm a boy who feels unhappy about being a boy. It's the role of the regulator.
Can I? Sorry. Next question. So we can absolutely. You can come at the end and speak to these ladies, but we have a number of questions and we've got 7 minutes left. So I would like to ask you for now, and you can absolutely come up afterwards. They're going to stay around. You can come afterwards. I'd like to ask you, because we have nearly 3,000 Lib Dem councillors, could you tell us what they should be doing in terms of the public sector equality duty?
Okay, all right, mate. What do you mean, what should they be doing? What should they be doing in general? They should be complying with the public sector equality duty, which means, in the first place, understanding what the protected characteristics are and that they're separate from each other. In the second place, taking each one of them separately into account in their decision making. And in the third place, understanding what the duty is. And the duty is to pay due regard to the need to achieve certain outcomes. It is not to achieve those outcomes. There is a difference between paying due regard to the need and achieving particular outcomes. So they should be, when designing a new policy or a new service or something of that sort, they should be looking at the impact on women, men, people with a protected characteristic of gender reassignment, lesbians, gay men, bisexuals, different race groups, different religious groups, people of different ages, etc. Putting that, setting it all out and thinking about it, how it all plays out together, and if there is a disproportionate impact, negative impact on a group, then seeing what can be done to mitigate that. That's what the duty is for and what it's about. It's not a weapon. It's supposed to be a tool that helps public authorities reach fair outcomes.
Thanks, Akua. And I just had a really quick follow-up to that, if that's okay. Quite a lot of our councils have been passing these sort of trans policies following the Supreme Court judgment. A couple of past ones about the Supreme Court judgment and how it clarifies the law for women. And people have been worried about the public sector equality duty in terms of it's supposed to foster good relations between different groups, and have been worried that it's prioritising actually one group over the other by passing these motions. I wasn't sure if anyone would like to comment on that.
I mean, do you want to pick that up as well? Yeah, I mean, it's a very performative motion, isn't it? It's a motion that trans women are women and trans men are men and non-binary people are valid. It has no apparent relevance or meaning to, in relation to anything. I mean, if what it means is we're going to continue to break the law, then, it's surely outside the competence of the council to pass the motion. If what it means is these are our beliefs, then fine, but have a think about what the impact is of that on people with a protected characteristic of gender critical belief, people with different protected characteristics which are negatively affected by adopting such a very partial ideological standpoint. Anything else you want to add to that?
Okay, thanks, Akua. Any more questions in the room? Ulrika.
Thanks. There's this point in the Equality Act about you're allowed to exclude somebody who has the protected characteristic of gender reassignment, and that is now applied to, as I understand, is that correct, people of the same sex who may have changed so much that they also might cause anxiety or discontent.
Yeah, it's paragraph 28. Yeah. Do you want me to comment on that? Sorry, I'm taking all the questions. They're all legal questions. You're not paying me. So paragraph 28. Yeah, I mean this is at the heart of the issue, and I'm very, I could talk about paragraph 28 of Schedule 3 to the Equality Act all night, and those of you who corner me in the bar might manage to get me to do so. But yes, effectively, it was a wrinkle. There was a wrinkle in it where it was difficult to know what that paragraph was there for. The one that said when you've got a single-sex service, you can exclude trans people from it. That's essentially what it said, and it was there was a real confusion amongst lawyers about what it meant and what the consequences of that were for other parts of the Act and how it all fitted together. And what the Supreme Court said was what that paragraph is for when a trans person really passes, then they can be excluded from the service that's for people of their own biological sex. So a trans man can be excluded from a women's service and a trans woman can be excluded from a men's service if, it would be a proportionate means of achieving a legitimate aim to do so. And that should be done on a case-by-case basis. There should never be a blanket rule that a trans person isn't allowed to use the services for their own sex. It should always be based on the individual case, because it would be unfair to go blanket rule on that. It would be unfair to trans people to go for the blanket rule on that. But that is what the Supreme Court said, and I have been personally accused of making this up myself, and I really didn't. I mean, this is what the judgment says. People have to grapple with the fact that this is what the judgment says. It's not a lie, it's not something that has been made up to upset people, it's the law. So let's start from where the law is.
Thank you, Akua. Is that okay, Ulrika? Thank you.
Yeah, I totally agree.
We've only got time for one last question online, and this has come from Vicky. What can we do about the inaccurate data that is collected and reported in relation to crime stats? For example, there are men who identify as women who are committing crimes which are being reported as female crimes and being attributed to female crime in crime statistics. Maya?
I think this is the next frontier. I think we've clarified the law. The law is really clear. The data is a mess. And trans rights is the right not to be discriminated against. It's also the right to privacy. You don't always need to declare your sex. For example, when you're buying alcohol in the supermarket, they only need to know you're over 18. They don't need to know your sex. So in situations where the state or a business or an organisation doesn't need to know someone's sex, it doesn't need to record it. But where it does record it, it should be accurate. And that's just a principle of data protection. All your data should be accurate everywhere. And that counts for everybody. The problem with accommodating trans people's privacy by recording their data inaccurately means that the whole data set becomes inaccurate. So it's not just a problem that there are a small number of trans people who are recorded as the wrong sex in crime statistics, and it's a small number, but remember 98% of sex crimes are done by males. So you only need a few males in the female category to make a big difference to those statistics. But in any case, if a particular category of statistics are not accurate, you can't say whether anybody's data is accurate. And this is why when you go to get an X-ray at the hospital, they ask men, all men, could you possibly be pregnant? Because they look at their screen and the screen says male, but they can't trust their own data, so they have to double check and say, could you possibly be pregnant? And that's, just add up the number of NHS minutes that wastes. It's not necessary. The M in a government database should mean male, and the F in a government database should mean female, and prefer not to say can often be an option when it's not about healthcare, or it's not about single-sex services. You just don't need to know a person's sex. And they can declare their pronouns, they can change their name, they can be asked to be called whatever title they want, but sex needs to be kept accurate because that data is important for everyone's safety as an individual and as a society.
And for combating violence against women and girls.
Thank you. Now, we do have some more questions online. We can't answer them now because there are people waiting at the door to come in. However, anybody who's got any more questions, by all means, come to us later and we'll try and deal with those in another manner. I'd like to thank you both, all three of you, for coming along. Thank you so much. And please, if you care to join us in the bar, we can discuss some of these issues further. Thank you so much.